I can't believe everyone doesn't know this about personal injury lawyers. One of the most frequently asked questions we get almost on a daily basis is how much does it cost me to retain your firm for my personal injury case? My name is Phil Rizzuto of the Rizzuto Law Firm, and we represent clients who are involved in personal injury accidents all over the state, all over Long Island, all 5 boroughs of New York City, Westchester, and beyond. And here's the answer. The answer is nothing. We only get paid if you get paid. This is not unique to our firm. This is common practice among personal injury attorneys throughout the country. We work on a contingency fee basis, which means we get a percentage of the recovery we get for the client, and it is contingent upon getting a recovery for the client. However, there are some factors that make our firm unique. Our fee is 1/3 of either the gross recovery or the net recovery. In our client engagement letter, we give the client 2 options. Option 1 is they can have the fee calculated off of the net recovery, which means there's a gross settlement, we get our case disbursements back, and then the fee is calculated or after we take the case disbursement. This generally results in a higher recovery for the client and a lower legal fee. However, if there are any liens, they do get paid out of the client's share. Option 2 is the fee is calculated off of the gross recovery, which means there is a gross settlement. The fee is 1/3 of the gross settlement. Then we take our case disbursements back and the net goes to the client. This results in a higher legal fee to the firm and less of the proceeds to the client. So why would a client choose option 2 instead of option 1? The answer is simple. In option 1, the client has the risk of paying back the case disbursements if there is no recovery. On the option 2, the client takes no risk. There is no risk to the client if there is no recovery. Case disbursements are the money the firm lays out in order to litigate the case. Cost of getting medical records, the cost of filing fees with the court, cost of hiring experts, of hiring investigators. All of those are case disbursements that are incurred as the case progresses. Some of the cases, the case disbursements are under $100 or in the hundreds of dollars. Some of the cases, especially the cases that go to trial, could be tens of thousands of dollars in case disbursements. We've had cases where the case disbursements were $50,000, $75,000. Some cases, they could be over $100,000. It used to be that clients only had one option, and that was the first option, where the fee was calculated off of the net recovery, and if there was no recovery, the client had to pay the case disbursements back. But the law changed to give the client the second option, where there was no risk that they had to pay case disbursements back if there was no recovery. So when this happened, there were attorneys who wanted the client to choose option number 2 because it resulted in more money to the firm. In order to do this, they told the clients if they wanted option 1, they had to leave a deposit, and the attorney would put the money in escrow, and they would pay the case disbursements as the case proceeded with the client's money. And when the money ran out, they would ask the client for more money. We never did that. We always told the client, we will pay the case disbursements, and at the end, one way or the other, we will take it back. The next question clients will always ask is, what option should I choose? Should I choose option 1 or should I choose option 2? I always tell the client, it doesn't matter to me. It depends on what they are comfortable with. If you have a big tolerance for risk, you may want to choose option 1. If you have no tolerance for risk, you should choose option 2. Most clients will choose option 2 because they have no tolerance for risk. They don't want to think about it. They want us to handle the case and not have to worry about ever having to pay back the case disbursements. And in most cases, the difference ends up being not that much. So it is worth the client's peace of mind to choose option 2. So here's an example. In New York State, in order to recover for damages in a personal injury case, client has to sustain a serious injury as defined in the New York State insurance law. So if a client is stopped and hit in the rear by a FedEx truck and they have a fracture, which is one of the elements of a serious injury, they should choose option 1, and I will tell them to choose option 1 because the likelihood that there will be no recovery is very slim. Nothing is ever guaranteed, but in a case like that, you have liability, you have an injury, and you have a deep pocket that has the ability to pay for the damage. In that case, I would tell the client you should choose option one. And quite frankly, if we didn't get a recovery in that situation, I would eat the expenses as a loss. However, if a client is involved in an accident at an intersection, as a question of who had a red light and who had a green light, and the client had soft tissue injuries, it's not so clear cut if there will be a recovery, because we will have to get medical documentation to prove that they sustained a permanent injury or a significant limitation of a body function or system, which meets the serious injury definition. But the insurance company is going to fight that, and they're going to say that they don't have a permanent injury or a significant limitation. So it's not so clear cut, and liability in that situation may not be clear cut. In that case, the client may want to choose option number two. Generally, I leave it to the client's comfort level. Most clients will choose option two because they don't want the risk, but whatever the client decides, I will support. We just actually had a case where the client was injured through an anesthetician. She was getting some laser treatment done to her face. The defendants made a motion for summary judgment, and the court found that the anesthetician, the defendant in the case, did nothing wrong, and they dismissed the case. We incurred over $7,000 in case disbursements between the medical records and hiring experts. The fees were over $7,000. Client chose option two, so she does not have to pay that money back. We will take it as a loss, and the client is happy that she does not have to pay the money back. Another thing clients need to be aware of is that if there are any liens on their case, they have to pay them back, and they come out of the client's proceeds. They are not case disbursements. They are not part of the legal fee. They are the client's responsibility to pay. And when we settle a case, there is language in the settlement agreement that requires the client to hold harmless the defendant and their insurance company from any liens, known or unknown, because there are times where after a lawsuit is resolved, certain liens will pop up. And ultimately, it is the client's responsibility. We make every effort we can to determine what liens are existing before we disperse the proceeds. This way, we can pay them when we get the money. The way a settlement works is once the settlement check comes in, it's made payable to the firm and to the client. We deposit the money in our escrow account, the check clears, and then we disperse the settlement proceeds. Client gets their share. We take our fee, we take our case disbursements in two separate checks, and if there are any liens, we pay them from the settlement proceeds. If a lien pops up after the fact, the client then has to pay them themselves. Types of liens that have to be paid back are workers' compensation, social services, Medicare, Medicaid. If you are insured under an ERISA healthcare plan, the ERISA healthcare plan gets to get paid back. It used to be that all health insurance carriers would be paid back for money they paid as a result of treatment from an accident. However, Governor Patterson issued a law saying that health insurance carriers are not permitted to be paid back from settlement proceeds in a personal injury case. Only if the health insurer is an ERISA-funded plan can they get their money back. Another thing that makes us unique and different from other firms is we don't charge to negotiate the liens. Under the law, we are entitled to take a fee on the reduction of the lien. If we have a lien that's $100,000 and we reduce it by $30,000, technically we could take a $10,000 fee. I have never taken a fee to do that. A lot of firms will, or a lot of firms will hire an outside company to negotiate a reduction in the lien so they don't have to do the work and they can disperse that expense as a case disbursement. But that results in less money to the client. We will do it in-house and we will make every attempt to reduce the lien as much as possible because it puts more money in your pocket. There are some very rare occasions where we actually will hire an outside company to negotiate the lien. And those are situations where the lien is very high. We've actually had cases where a Medicare or Medicaid lien was extremely high and it exceeded the settlement proceeds. And we can't negotiate those liens until we have a settlement. One thing I tell the clients is we have always worked it out. We have always been able to work out a lien, but there have been a few occasions, 1, 2, 3 at the most, where we have hired an outside company to get involved and to do that. And believe me, it was worth us doing it. It was worth it for the client to have us send this to the outside company. If you want more information on the different types of liens and how they affect your case, subscribe to my channel and watch my video on liens. Now, once the case is settled, if If you choose option 1, we take the gross settlement, we take the case disbursements, we subtract the gross settlement from the case disbursements, and then we get the net proceeds. A third of net proceeds is a legal fee. The remaining balance is the client's proceeds, and if there are any liens, they are paid from the client's proceeds, and the net result goes to the client. If there are no liens, we pay the client proceeds directly to the client. If the client chooses option 2, the fee is calculated off of the gross settlement, then the case disbursements are reimbursed to the firm, then the net result is the client proceeds. If there are any liens, they are paid from the client proceeds, and the checks are dispersed. If there are no liens, then there is a check issued to the firm for the fee. There is a check issued to the firm for case disbursements. Client's proceeds check gets sent to the clients. We always give the clients the option to come into the office and pick up the check in person because they're usually happy and they're happy to see us and we're happy to see them. Sometimes they don't want to be bothered and we'll send them the check. Another question we sometimes get when reviewing the client engagement letter with the client: is the fee negotiable? The answer is no. The fee is not negotiable. There are some states that get 40% on a contingency fee basis. The fee we take of a third is pretty much standard throughout the state. We offer a lot of benefits to the clients where we don't, if you choose option 2, we do not take the case disbursements up front. We do not charge you for the case disbursements along the way. We will negotiate the lien at the end of the case and we will not charge you. And we will not send it out unless it's a very rare situation where it's in everybody's best interest that we do. Another benefit that clients get from hiring us, we have represented insurance companies and municipalities and self-insured institutions as defendants. So we have represented defendants in personal injury cases as well as plaintiffs, and we've done it for a number of years. So we know how both sides work. We know how the insurance companies work. Finally, we have to file a statement with the Office of Court Administration explaining what the fee arrangement is. So we cannot deviate from that. Unfortunately, the fee is not negotiable. Most law firms, most reputable law firms, will never negotiate the fee because we work hard and we take a risk that there will be no recovery in a case. Luckily, we're selective on the cases we take. Most firms are selective on the cases that they take, and we have a habit of winning cases, not losing them. But we will do our best for you. We will fight hard, and we will go to bat for you from the beginning until the end. And we will do everything in our power to put as much money in your pocket that we can. If you have questions about how we are compensated with respect to your case or questions about personal injury matters in general, ring Rizzuto at 855-RIZZUTO. We'll be happy to help. If you found this information helpful, subscribe to the channel, follow for more, and we'll see you next time.